Hello all, myself Vedangi and I am a legal intern at LEXIS and Company. And my another topic for today's discussion is the case analysis of Mohini Jain versus State of Karnataka. Mohini Jain versus State of Karnataka is a landmark judgment that led to the right of education. In this case, Mohini Jain was the petitioner and the state of Karnataka and others were the respondent. Talking about the background of this case, so the state government of Karnataka issued a notification dated 5 June 1989 under section 5 subsection 1 of the Karnataka Educational Institution Prohibition of Capitation Fee Act 1984, fixing the tuition fee and the other fee that need to be charged from the students by the private medical colleges in the state. So as per the order, three different slab rates were fixed. First of all, for the students admitted against the government seats, they needed to pay the tuition fee for rupees 2000 per year, and for the Karnataka students other than those admitted against the government seats, they had to pay maximum tuition fee of rupees 25000, and the students belonging to the category of Indian students other than and outside Karnataka, they were to pay a tuition fee of not exceeding rupees 60000 per annum. Mohini Jain was a resident of state of Uttar Pradesh and she came under the category of Indian students outside Karnataka. Mohini Jain was informed by Sri Siddhartha, a private medical college in Karnataka, that she could be admitted in their medical course only if she pays rupees 60000 as the tuition fee for the first year and also furnishes a bank guarantee in respect of the fee for the remaining years of the medical course. When she could not pay that high amount of tuition fee, she was denied to get the admission. So she filed a petition under Article 32 of the Constitution and she challenged the notification dated 5 June 1989 issued by the government of Karnataka, which permitted private colleges to charge exorbitant fee from the students other than those who were admitted to the governmental seats. After that, there are certain legal issues that are involved in this case. First one was whether the constitution of our country guarantees the right to education. Second was whether charging such a high fee is violative of the right to education. Whether charging a capitation fee in educational institute violates our Article 14, which provides for equality before the law, and whether the notification issued by the government of Karnataka permitted the private medical colleges to charge capitation fee under the Act of Karnataka, and whether the notification was violative of the provisions of Karnataka Educational Institution Prohibition of Capitation Fee Act 1984. So there were certain arguments that were submitted on the sides of both the parties. So the petitioner contended that imposition of such a high fee on the part of the educational institution is against the article of our constitution. In that situation, the respondent contended that at first the criteria that was allowed in the private medical college regarding the capitation fee is not chargeable from those students who were issued the government seats. It is charged only from those who have not been issued the government seats. Also, they argued that as they were following such classification of seats in the college under merit list and under non-meritorious list, so only those students are entitled to pay the capitation fee who are not under the merit list. Another argument presented by the respondent was that as they were a private medical college and they were not funded by the government of Karnataka, so they practically needed some amount, and also they had to spend rupees 5 lakhs as an expenditure for the MBBS course. So they contended that it was justifiable on their part to charge the capitation fee. Lastly, they submitted that there was no provision under the constitution or under any other act except the law passed by the state of government which provided for the charging of the capitation fee. Now, what was the judgment of this case? So after hearing the arguments of both the parties, the Supreme Court held that though the right to education has not been provided under our constitution, but still Article 38, Article 39 Clause E, Article 39 Clause F, Article 41 and Article 45 of the Constitution, they clearly provide that Constitution make it obligatory for the state to provide education for all the citizens. The Supreme Court also observed that without making a provision for the right to education under Article 41, that will be completely violative of our fundamental rights, as it is denying right to education to the citizens. So based on this reasoning, the Supreme Court held that right to education is an inherent part of the fundamental rights provided under Part 3 of the Constitution. The court also observed that right to education flows directly from the right to life, so the state government is under the obligation to make a provision to provide educational facilities to all the levels of the citizens. Also, charging such a huge amount of fees from the people who belong to lower class and they are not able to pay such a huge amount of fee is basically denying them and depriving them of the right to education. So this is violative of the Article 14 of our Indian Constitution. The court observed that Karnataka Educational Institution Prohibition of Capitation Fee Act 1984 was brought with the objective to curb the evil practice of collecting capitation fee from the students to get them admitted in the educational institutions in Karnataka. So the court further observed that if the state government has fixed rupees 2000 per annum as the tuition fee and the government seats in private medical college also, then the state government should take into consideration that every institution should charge only that much amount as capitation fee, not above than that. So the court held that charging capitation fee by the private educational institution is basically illegal and it cannot be permitted. So the court set aside the notification dated 5th June 1985, declaring that such a declaration and such a notification is beyond the scope of the act and contrary to section 3 of this act. Now, what was the impact of this judgment? So prior to this judgment, the right to education was not provided under the constitution. So the parliament in 2002 passed Constitutional 86th Amendment Act 2002 and thereby added Article 21A under the Constitution and recognized that the right to education is a fundamental right. Now talking about the conclusion part, so the Honorable Court modeled its decision on the dignity, on the principles of social welfare and equity. Also, the judgment is much ahead of its time and the court was very much diligent in interpretation of what amounted to the charging of capitation fee and how the court linked the right to education and made it a part of fundamental right is very commendable. So the court emphasized that the right to equal opportunity is an integral part of our fundamental rights and also the right to education flows from the right to life. Also, the court placed more emphasis on the merit rather than the financial capital. So guys, that's all about my discussion on this particular case. I hope you all liked my video. If you guys have any doubt with regard to this video or to the previous one, then you can comment in the comment section. Also, don't forget to subscribe to our YouTube channel Lexcliq. We will meet in the next video with a new topic. Till then, bye.